Welcome to the Real Estate Majlis podcast, where we dive into the latest real estate insights and trends. Whether you are a seasoned investor or a first-time buyer, our podcast is here to provide valuable information and expert advice. This episode is powered by Bayut, the UAE's leading property platform and proud member of the Dubizo Group. Whether you're buying, selling, or renting, Bayut connects you with real estate solutions tailored to your needs using innovative tools like TrueCheck, TrueEstimate, TrueBroker, and Bayut GPT. From finding your next home to advertising your listings with confidence, Bayut offers real photos, real prices, and real properties, helping you make informed decisions in the market. So welcome to a new episode of the Real Estate Majlis podcast.
Today we have a very special lawyer that I know for a long time in my government position, Ludmila Yamalova, who is the co-founder and partner of LYLAW in Dubai, a very well-known lawyer in the real estate industry. So welcome to the episode.
Welcome. Very excited to have you here.
Thank you. I'm very pleased to be here. Thank you for the invitation.
So the first question, what are the common legal mistakes that you've seen in your experience from buyers or sellers? What are the costs that comes from such mistakes?
Well, the mistakes here are actually fairly basic. They start with just lack of basic due diligence. Due diligence meaning just asking the right questions about very basic information about who you're buying the property from. Is this the developer, or is this a party that's reselling the property? Who is that party, and what's the project? Is there a title deed? Is the title deed actually issued? Is the title deed in the name of one owner or multiple owners? What are the specifications of the property? Does the property have parking attached to it? Is there a mortgage attached to the property? And are there unpaid service fees, and so on and so forth? So the biggest problem we see is just almost lack of interest in due diligence, lack of interest in knowing those basic bits of information. And that is coupled with this propensity to rush, to just this eagerness to close the deal, to sign the document, to part with money. It's a bit very, very special for Dubai, I have to tell you, because in other jurisdictions, people, when they buy real estate, they go to lawyers. Yeah, there's a lot of documents and a lot of due diligence, and sort of fairly lengthy process that goes on. And nothing, even $10,000 does not get transferred until all the T's have been crossed and the I's are dotted. Here, people tend to, and as Mahmoud rightfully said, we've known each other for a very long time, and things have improved tremendously. But when we first met over a decade ago, I remember I used to always say people literally sign documents with their eyes closed. Like they would give millions of dollars on the back of a paper napkin. Now things have improved since then, but they're still, there's still a lot of the same practices continue. So people are very eager to just sign a document, and it's one thing when you sign the document. It's another thing when you sign a document and you give money or issue a check. And there's just so that's one of the perhaps still continuous surprises that I see or I experience, is that how eager people are to first give money to sign a document, and then they come and ask questions.
What about the problem?
So it's based. So those are two things: is just not wanting to know enough, and then rushing, and that again is coupled with just wanting this kind of attitude of wanting to hear what they want to hear. So they want to hear the story of like this beautiful story of this is an amazing project. You're going to make so much money here, and and you can flip it in the next few months and triple your investment.
And this is the last unit. We buy it. You don't have time.
Yes, and if
pushing from broker side.
Exactly. If you don't sign it right now, this is the last one. If you don't sign it now, tomorrow will be 30% more, and it will be gone off the shelves altogether. So and this is, by the way, this is also one of perhaps kind of a consequence of that, is that they don't like us. They don't like to come to lawyers because we will tell them, let's
slow down the whole process.
Let's kind of ask this basic information, and then we can come up with a strategy or an action plan. And they don't like that because they much prefer to follow this beautiful story of like, this is an amazing one of a kind investment. One of the biggest legal problems that comes from this that we see is it's less about the document you sign. It's just when you sign the document, you part with your money. And then parting with the money happens either by virtue of a check or, in the past, there's a lot of cash that was exchanged as well. So, and that's in the form of a deposit. And then when they start asking questions, okay, so when does my SBA come in? The SBA doesn't come in within a certain period of time, then they start worrying. Then they want the deposit back. And so it really comes out, most of the disputes we see relate to the deposit. It's less about terminating that particular agreement. It's more about, well, now I want to back away, but my money is with someone else.
Yeah. Today, obviously, we have forms that are mandatory by the government, especially in Dubai. So when you take the Form F, I think one of the questions that people always ask is, I signed a Form F, but then there was that additional terms and conditions that the brokers freely type words and say, if this happens, this is the consequence. And sometimes whatever they write contradicts in the principle of the Form F itself. So what buyers should be aware when signing a standardized form and having these additional clauses that might not necessarily be legal?
I have my personal view on this, the Form F. I mean, Form F, what is this? Ultimately, it's supposed to be a contract. It's a contract, an agreement between two parties, right? And so when you talk about an agreement is, generally speaking, a voluntary instrument. So the parties should be able to agree to whatever terms and conditions they want to agree. Now, the Form F was introduced, I remember was introduced is to bring in some kind of a standard, some kind of a even playing field for investors in Dubai. And it was much welcomed at the time, but what we, from a legal standpoint, we see it's a little restrictive. We understand the purpose of it, but it is restrictive in the sense that, like you rightfully said, if you want to introduce new terms, and let's face it, every transaction is different, people's circumstances are different.
Correct.
So how do you deal with those terms which are either not addressed in the template, or they somewhat contradict the
Form F itself.
Form itself, or you want to introduce conditions that if some of the conditions or the provisions in the Form F are not met, the parties can come up with some sort of an alternative strategy. So how do you deal with that? And so that's why there's this addendum and the additional terms come out of necessity. Necessity because in order for the parties to memorialize the actual agreement of the terms and conditions, you need to include them somewhere. And it just happens so that, yes, you're absolutely right, that often there is a discrepancy between the two. And in fact, in the same Form F, there's a kind of a catch-all provision at the end. And if there's any discrepancy, that this template will supersede. So there's also that additional layer of complexity. Now, what I would say, but it's not easy to do. We've even tried to go into the form itself and change in the form itself. But there's some spaces where you can kind of add a little bit of variation, but not very much. So sometimes I guess maybe cross them out. We've tried to do that. It's it's not a perfect solution, but it is better than what used to be. And I think it gives a lot of investors a sense of some kind of comfort because there's a common playing field. So, but those kinds of problems, unfortunately, are all too real and too common because the current Form F is not flexible enough and is not comprehensive enough to account for every possible eventuality. So, for example, and the deposit, the deposit is like it's 20% if buyer breaches versus seller breaches. So there's a lot of disputes about the deposit, and parties sometimes don't actually want to put a deposit, but they feel kind of bound by this template. Which again, this is just a template; it's an agreement. Yeah. They should be able to take it or leave it. So. It's it's a step in the right direction, but I do wish for this form to be eventually made a little more flexible, just like the case has been, for example, with all of the free zones, the employment agreements, right? There was a time that a lot of these incorporation documents and employment agreements in every free zone were templates. Now they're a lot more flexible and they're a lot more business friendly.
In terms actually of security deposit, I know that it can be zero if you want to add in the form itself. Form F, as far as I know, RERA is working now on updating it. So I think
Great news.
your
so excited to hear that.
contribution is important. At that time, I think, as you said, it was about standardization. We wanted the process to be faster.
And it helped.
We have 217 nationalities of investors. So we want a more of a standard protection for them. However, I think we now reach a stage in the market where we need maybe Form F to be upgraded to the next level. People make more mistakes in off-plan properties rather than existing. Or have you seen the other way around?
Indeed, yes, because it's easier to make mistakes with off-plan properties rather than existing. Because existing property, you go, you see, you touch it, you feel it, you know what you're buying, you know that it's ready, you know if you see any kind of issues, what the issues are, you know who the seller is, and you know what the amount is. Not much is going to change between, and you know that you need to pay within a short period of time. Whereas with off-plan, I mean, you're making your decisions on the basis of a very pretty brochure, and you and I remember the very fancy leather-bound brochures that people paid millions and millions of dollars on, which never came to be. So obviously people, all they have to go by is just pictures, flyers, posters, ads, and representations. But they don't really, they cannot touch and see. And then a lot of the photos you see and videos have this magnificent open skyline and then so there's issues with off-plan or what? Timing, when the property is going to be finished. From our experience, we see that to this day, investors will rely on the representations of what they hear from brokers and from the developers as to when the project is going to be finished, not what the contract says, or the piece of paper upon which they actually are signing and giving money. So they rely on that, and they don't really question what that means. That's one issue. The other one is the specifications. So, for example, it's going to, so in their mind, because they're relying on the picture, it's going to have unobstructed view, for example, or it's going to be a certain size because they're not reading the fine print in terms of the size. The size, they're not reading that the size includes a terrace, and a terrace could be half the size of the unit. So then when the property is transferred or is handed over, they all of a sudden they realize the property is too small. It's only half the size of what they expected because they didn't read the fine print. So another issue related to off-plan is payments for milestones, right? By law, every payment should be linked to construction milestone.
Correct, yeah.
And now DLD has this amazing system where you can track every project and you can see the construction milestones, and the law is pretty clear about payments being linked to construction milestones. And that's huge security that's been introduced in the market, not so many years ago. But a lot of the time, there's people they don't know that, and they don't want to hear that. So they pay as per what is in the contract, and then when fast forward 2-3 years, they see that not much has happened yet. The property's not being built. They don't want to pay anymore. They don't want to pay. Then the developer is upset because they're expecting that next payment. Yeah. So those are the issues basically that arise.
Especially the worst thing when investors pay outside the escrow account. That's a disaster.
Yes. And that happens a lot still to this day with the booking form and the deposit. So somehow we'll have had recently a few clients who've come. They've already paid the booking fee, which is not insignificant, and when you ask, okay, who did you pay to? We paid the developer, but do you have a check or receipt? There's nothing. They still do not ask, as I said earlier, they don't ask the basic questions. Who is this check issued to? Which account is it going to go on to? And am I even supposed to be issuing this check in the name of Mahmoud, for example? And that still happens today.
There was a question which referred to what you're saying from one of our followers, and he wrote a story saying, I bought from a prominent developer. The master plan showed that next to my home there was a pool and there was a community center, and now as the unit's getting close to handover, I was informed that none of that exists anymore. In fact, they put at the lake in front of his villa, and there was a road. It's not, even from a drawing perspective, you could never imagine they would put a lake in front of the house. And he's saying, what do I do? Is there any recourse, or the developers now have wording on the sales and purchase agreement that gives them the right to change the master plan? And because those are significant changes, right? You suddenly have a lake in front of your house. I'm sure people went through very deep decisions when choosing the unit, right?
Yeah, there's a different spin to that particular question, because I remember the time is that what the developers in that particular case would increase the price, because voila,
Absolutely,
now you
because
have
you
the
are
view,
next
you have
to the
next to the
yeah,
lake.
exactly, yeah. And I'm sure that
So
was
those-
the case as well. There was a premium on the unit for the location.
Yeah, and there wasn't, and there were, in the past there was no law allowing developers to do that, and they would do exactly that. Well, your unit is bigger all of a sudden,
Yeah.
and then or it has a nicer view. Remember that?
Right.
And then the law was introduced where it capped it to only a 5% difference
yeah.
only. Yeah. So it's a great question, and I've dealt with a lot of those questions over the years. There's a legal perspective and your position, and then there is the practical, right?
Right.
From a legal perspective, actually, it arguably all that is the representations of the road and the community center and the gardens and the pool and so on and so forth can also be part of a contract from a legal standpoint, because ultimately, what is a contract? What's an agreement? It's the booking form, it's the SPA, it's whatever the addendums, it's the checks, it's
Marketing
the emails, it's the
materials as
market.
well?
Yes, and the marketing materials are also considered to be part of the contract. The contract is a universe of all the documents that ultimately define the terms and conditions of a contract
Right.
or a party's agreement. So, from a legal standpoint, yes, those materials can also be considered part of the contract. Legally, you can argue for it. You cannot force a developer to all of a sudden remove the lake and put.
Of course,
you
but
can also
you
ask
could
for
get your money
compensation.
back
You
or get a
can.
compensation,
Yes,
or-
and we have done that for a few clients exactly for that reason. But ultimately, there was the legal position is there. From a practical standpoint, it means you need to go to court.
the
you
court
need to file a
and
court. You need to
depends
hire
on
an
the
expert.
judgment.
You know, well, the thing is, but the court's precedents are pretty consistent.
Right.
You know, if you argue well and if you cite the right provisions, the precedents and jurisprudence is pretty consistent. It's just, it takes time. And then there's an expert involved, and then there's a lot of documents, and parties get very upset. They want to go fight. But when the time comes to actually start spending money on lawyers, on
Yeah.
courts, and experts, submit documents, translate documents, find more evidence, and because that evidence is often does not exist in the way it should exist, because
Right.
they never asked the right questions, they didn't ever collect the documents or created the paper record that they should have, which would have helped them in this case. It's like how often clients will tell us, okay, well, we paid, but do you have a receipt that you paid? Well, no, I don't have a receipt that they paid. So legally, yes, it's an arguable position, and we have successfully argued that in the courts here. But from a practical standpoint, it's often too expensive and too cumbersome, and ultimately people just decide, well, and that's the advice we give them. If it's such a big issue, just sell it off to somebody else and move somewhere else,
Right.
you know, it ultimately, or
I think there's a reputation of the developer, right? So when a customer wants to challenge this, and the developer doesn't look at from a good faith perspective, obviously the reputation,
Yeah.
whether it's a good or bad, people will eventually know. So on the security deposit part as well, I think there is some misunderstanding, especially from customers, about if there is a dispute, you can go to the broker and get your check back, or ask the compensation check. I don't know, and maybe you can shed some light, if brokers are giving the check, or they are very clear or today that you have to go to court if there's a dispute.
The short answer is brokers are not allowed to give the check or the deposit, and that's because the broker's role in the transaction is one of trust.
Right.
So they're basically a trustee holding onto the check, and by very definition of a role, somebody a trustee is that they represent in a way both sides, and they're holding the check in trust. So if Mahmoud says, "Give me the check back," and you say, "No, give me the check back," and I'm the broker in the middle. So if I give it to Mahmoud, then I'm potentially breaching your trust. I'm giving it to you and potentially breaching his trust. And I'm in the middle. And so, but ultimately, how much do I get from it? So even from a practical standpoint, from a commercial standpoint, it's not worth the hassle or the risk. And so, but there was a time definitely where brokers would side with one side or another and give the check to the party, obviously, who would benefit from the check, and then they would get a cut from the check. But in legal terms, that was never really allowed, one. And then two, there's been a number of court precedents where that it clearly stated that the broker does not have the authority. Because ultimately, when that happens, it's a termination of contract. And in the UAE, there's this very specific jurisprudence that in a termination of contract, particularly for real estate, unless parties agree, on the termination,
mutually,
only
yeah.
the court has the authority to terminate the contract. So if you go by that theory, so I'm the broker, you two disagree, so I don't have if the court, the only one who has the jurisdiction or the authority to decide this, then I have no authority to do it. So there's a lot of jurisprudence on that front. And I think on the back of that, now most of these agreements with the brokers, and I think if my memory serves me right, even the Form F, it states there that if there's a dispute between the parties, then the parties have to go to court and obtain the decision from the court. And then on the basis of that decision, the broker will decide one way or the other.
Which is amazing and is the right thing to do. But I think there's a lot of confusion sometimes. And obviously when the heat of the emotion, people get, give me the check, the seller default, and vice versa. So it's just that they write sometimes on the contract that if there's a dispute, part of the deposit should come to them, and then maybe that's the reason they hold tight to the check, because they work hard for the deal, and then for some reason doesn't happen, then they're obviously at a loss as well.
A lot of people's cases and a lot of the contracts are drafted in such a way that if me as a broker, that I benefit more if you two fight. Then I get actually a bigger percentage as a commission.
It was 20%, right?
Yes,
it was like there was 80-20 kind of split.
I get more money, like double the money, than actually if the deal goes through and there's a successful transaction. And that's a proven concept. We've done the calculations.
It is a very interesting point of view, but we do not want to encourage them.
No, I'm just saying. So that's the way how the contracts are drafted.
Yeah.
So it's it can be easily corrected.
Yeah,
right.
Absolutely.
It's just that right now, unfortunately, and I think I believe is completely inadvertent, but that's what happens. Is in a way, it's more beneficial for me to step back and see you fight than for the deal to go through.
Continuation with Form F. Form F has an expiry date. If it's a cash, if it's a mortgage, a lot of issues comes in. So what happens on the expiry date? The deal hasn't been through. It's a cash or it's a mortgage. Two scenarios. So what can happen?
I personally think there should not be a deposit at all, because I think most of the disputes I see relate to the deposit, because ultimately if you
buyer or seller, you think both in general?
Yeah, in general, because if you're a buyer and you're a seller and you're a willing buyer and you're a willing seller, what's the deal? Like, right. I mean, it's just a matter of agreeing, signing the documents, agreeing on the date to go and exchange money. This is it.
Because today, most companies are actually charging the seller, asking the seller to pay a deposit. Both buyer and sellers pay a deposit. But you're right. I mean, the seller is putting the instrument, which is the property, right?
Yeah, but the point, the idea is that I look at it as a business transaction, a commercial transaction, where you have two interested parties that want to conclude a transaction, and there's no dispute. Well, why do you need the deposit? Like, if you have your money ready and you have your documents, NOCs ready, we can go tomorrow to the trustee center and transfer the property. Why the deposit? Most of the disputes, most of the negotiations, most of the documents actually relate, if you think about it, relate to the deposit and the conditions attached to the deposit, and what happens if the deal goes through, or it does not go through, or if the deadline is missed, and so on and so forth. And then people feel constrained because something in the Form F says that it has to be finished by such and such date.
Yes.
But if there is nothing like that, I mean, if you call Celia, say, I want to extend for another month. Is it okay with you? She says, oh, it's okay with me. Halas, you don't need to go and amend the contract. So I personally find that the deposit is unnecessary, because if you have two willing parties, it's an easy enough deal, and it doesn't need to be contentious. So that being said, you're right, it's a very common practice, and in most cases, most of the legal fees go to deal with the deposit.
I think one of the charges that now you're seeing happening a lot in the market is brokers, they charge their fees. There is a little bit of that debate on the merit, whether you must have a broker representing the seller, one broker representing the buyer. Sometimes one broker is representing both parties, which is probably most of the time. But then there is something that is kind of over the last 2 years called the conveyancing fees or the admin fees, with some additional fees that the brokers are charging customers on top of the commission.
I don't want to offend anyone,
no,
so I will try to be diplomatic. I will try to be diplomatic. It is not necessary to hire conveyancing firms, not necessary at all. My biggest problem, I guess, my biggest issue, if you think about how much money the brokers make on these deals, I believe for this much money, they need to do all the work.
Right.
And this is how it is in other countries.
Right.
So if you're getting your 2%, 3% of the purchase price, in some cases an inordinate amount of money, you should do as a broker from A to Z. So you should not need a conveyancing firm to do it for you.
Right.
If you compare what brokers make versus what lawyers would charge for a transaction, that lawyers charge a fraction of what the brokers make.
Right.
Okay, and the thing is, you should not even need the lawyers to represent the party if you have the brokers. So the broker should be able, for that money, they should be able to do everything from A to Z, from a legal standpoint, from the conveyancing standpoint, from the hand-holding standpoint. They should be doing everything for the amount of money because it's a significant amount of money.
And actually, there is nothing called in Dubai as conveyancing license. If you go to the economic department, you will not find it. If a buyer or a seller choose to have a company helps with the process
Sure.
and more assurance, especially when there is a mortgage, I think it's their choice. But being a brokerage company and having a conveyancing within that brokerage company, adding more charge here, more charge there, my opinion that shouldn't be the case.
Look, I get it. When the transaction is finished, the broker wants to move to the next deal. And they should have, if they're able to, have someone in the office who can carry the paperwork and support the customer through the end. However, there are some agencies that are here that not only they charge this admin fee, conveyancing fee, but if the broker doesn't charge the customer, it goes out from their own commission. So I think it's an interesting topic, and I think people should be aware that there's not it's something that buyers can refuse, I assume, if they don't want to pay.
It's a choice at the end.
It's a choice, yeah.
But it's interesting you say it's a choice, but you know how many people in the market don't know that? They think, and they're being told that you cannot do a transaction without a broker. This is what a lot of people are told. So you must go through the broker. You must pay the broker. But ultimately, if we know each other and I want to sell my property to you, we don't need to have a broker to help us.
Actually, we have statistics-wise, we have a lot of deals that goes without brokers.
Exactly.
It's registered without brokers. I know for the sake of
officially.
For the sake of time, I know that tenants and tenancies is a lot of big segment of who watch us today are tenants. A very critical question that I hear a lot is that a landlord now sees the rental prices skyrocketing. So he goes and gives an eviction 1 year notice. I want to use it personal use or I want to sell it. And then after 1 year, it's done. The guy evicts. And then a couple of months later, he goes and rent it back again. What are the risks here for the landlord? And what are the rights for the tenants?
Well, there's two things about what you just said. So you said the eviction notice has a clause about personal use or sale. So what we have seen is the RDC will actually invalidate those kinds of eviction notice because, so which one is it? Is it personal use or sale?
No, I'm saying two scenarios now.
But the thing is, I have seen a lot of eviction notices that state both examples. So there's also that angle. So those landlords who actually, I think the market is a lot more educated now and better informed than it used to be, but this was a very common example where eviction notices will include both. I'll decide what I want to do when the time comes, obviously because the actual reason was something else, right?
They want to sell their house.
Right. So RDC has since then made it fairly clear that if you need to state for the eviction notice to hold valid, it needs to state the exact reason. So if it's for personal use, it's for personal use. If it's for sale, it's for sale. There's two ways to handle it. One is if the property gets sold, then sort of it speaks for itself. The property has sold. If the property has not sold, the tenant can either just believe the landlord and move out, or can challenge the landlord because, as you rightfully said, there have been so many cases where landlords have used this tactic to ultimately evict the tenant, re-rent the property, and and then basically do it again and again and again. So what the tenants are a lot more educated now, a lot better informed. So what they're doing now, they will challenge the landlord, and they'll say, well, we don't believe that you are actually planning to sell or move, and they will just kind of hold down the fort, and then we'll leave it to most cases the landlord to file a case to try to evict. But in many cases, if the landlord did not actually want to sell the property, they will not file the case to evict. Because in most cases. So kind of the truth comes out that way. So that's one way of dealing with it. But the other way, and as you alluded earlier, is that the law has always, the Dubai rental law has not changed since 2008, and has always had a provision that if somebody is evicted wrongfully, and that is basically for a flawed reason or wrong reason for eviction, then they have a right to claim compensation. So the law has always stated that. So in other words, the tenant, if the tenant is evicted wrongfully, the tenant has the right to seek compensation from the landlord for a violation of the law.
And we've seen a lot of cases recently, by the way, of compensation, right?
Yes.
So how big can this number be?
So let me kind of maybe first define the legal parameters of how the compensation is outlined in the law. There's not much detail. It just says basically a tenant can seek compensation, and it's up to the court to decide what the compensation should be. So it's quite broad and rather subjective. What we have seen, the usual compensation seemed to be for a while just a certain amount of money, like 25,000 or 50,000. That's what we saw. Since then, we've seen a lot more tenants, armed with a lot more information and a lot more documents, a lot more proof, where they'll actually show what they have suffered. Because if you parse out the idea of the word compensation, it's compensation for what? For a violation of the law, but it's a compensation for the damage that have suffered as a result of you violating the law. So then how do you define that? Is basically show, okay, this is how much I have lost because you wrongfully evicted me. How do you show that? You can show, for example, the moving expenses, right? The rent that you're paying, and by law, you're not supposed to re-rent it. If you're evicting somebody for personal use, you're not supposed to do it for 2 years, right? So basically, you can show the place analogous place that I was paying 100,000 dirhams, now I pay 150,000 dirhams,
and even more, right?
Just by way of example. So now the tenants are starting to make those more sophisticated arguments, if you will.
Right.
So they will actually keep track of all the receipts and they'll keep track of the payments that they're making. But the thing is, the property has to also be analogous. In some cases, somebody got moved, let's say evicted from a 3-bedroom villa, and all they can now rent is a 1-bedroom apartment. It's a little harder argument to justify. So there's also that nuance. But the courts are becoming a lot more also aware of what is happening in the market, and they're a lot more attentive now to these arguments by the tenants, and we've even seen experts now being appointed for the first time in a while. We've seen experts being appointed to decide, what the compensation is. So recently, to your earlier question, Mahmoud, it was that we saw compensation up to 200,000 dirhams for somebody who actually was able to justify the expenses that they had to pay as a result of wrongful eviction. And that's because they could not find a comparable place, and they were forced to move into a hotel, like a long-term accommodation. It's a lot easier to justify there because their invoice clearly shows how much you paid.
Right.
So we've seen it over 200,000 dirhams for just a 2-bedroom apartment, just to give context. So the range from 25,000 to 50,000 now we've seen to 200 plus thousand. So I hope that the idea here is to convey clearly the message. So there's enough of a deterrent there for the landlords to continue to do this.
So the message to landlords: don't evict if your plan is to re-rent it, because you're going to pay big price for that.
Well, it's interesting you say that, because for a lot of landlords, in some of their cases, it's worth it. Because they think they can re-rent it for even more.
So then everybody will be happy. Everybody's getting compensated.
But
they should be upfront. Say, listen, let me give you this amount of money for your trouble, right? And
this is a great point, because now that's another trend that is happening now. That is now landlords and tenants are now having that dialogue where the landlord will say, I will pay you X amount more, to basically move out. Will you move out? And so just to move out. And so there's another deal to brokers. So it's the market is becoming a lot more creative.
I'm going to give you a little bit of more complex question in terms of the nuances around selling a property. There is a tenant. There was a little bit of a precedent that the first owner gives a notice, then the new owner comes, he has to give a notice again. Now it seems there's some precedent where you do not need to do this anymore, and therefore the first notice will survive. But in between that, sometimes you have a renewal as well. And I think the new owner says, can I increase the rent even if I'm doing 90 days notice, yes or no? Because maybe the property is being rented for a long time. He now is the owner. He will, let's say, still there is 10 months on the tenancy and the renewal comes. If you are within the 90 days notice, can you increase the rent, or you have to continue on the existing?
The renewal or an increase in rent and the renewal of contract is still subject to certain conditions, which are subject to the parties' acceptance. So as a new landlord, I can say, yes, you have to accept, because it's an agreement. Okay. So you have to accept. So if you think that, yes, your property is now worth, let's say 150,000 versus 100,000 dirhams, and you even have precedents to show that, I still have to agree. So I may not agree. I may not be right in disagreeing, but I have the right to disagree and not accept, which puts you in a defensive position, which means that you have to now, what do? You either let me serve they stay there for the remaining 10 months and pay what I was paying, or you take me to court and you start arguing. And it's just ultimately, from a commercial standpoint, and that's what we advise a lot of our clients, it's just not worth it. If the contract is expiring in X number of months, it's just better you just wait, because you're going to have to pay money still to lawyers, to RDC, to experts, for translations, and just not to mention the emotional toll that it takes on parties. So we just say, just let them be. If you know you're going to take over the property, just let them stay there until the end.
Let the tenancy finishes.
Yeah, so it's more of a commercial approach.
Ludmila, it was so amazing having you here. I think you have answered so many important and pressing questions that a lot of our followers are asking. So thank you so much for that. And Mahmoud, thank you for your contribution as always.
Thank you so much.
My pleasure.
I hope to see you soon.
My pleasure.
Thank you.
Thank you.
Thank you.